If you're a director ignoring your duties during and just before insolvency, it could cost you personally. Now, I'm not just talking about your company's money, but potentially your own personal assets. Houses, buy-to-lets, other business interests and savings. It's not a theory. Directors across the UK right now in 2024 are facing personal liability, often without even realising it. Now, in today's video, I'm going to break down what your legal responsibilities are when your company's insolvent, and I'm going to show you steps you need to take to protect yourself and your assets. So listen, if you're a director, this information could be crucial. Let's make sure you understand exactly what you need to do. So listen, let's start with the basics. What does it actually mean for a company to be insolvent? Now, insolvency occurs when a business can no longer meet its financial obligations as they come due, or if its liabilities outweigh its assets. Simply put is, if you're not paying your bills on time, if you can't pay the HMRC bill when it's due, or if you're in a time to pay arrangement currently, you can't pay your suppliers this month, you're insolvent. If your liabilities are more than your assets, you're insolvent. Now, the key indicators of insolvency are struggling to pay bills, receiving creditor demands, failing to meet payroll. These are all massive red flags. Now, if you're in this situation, the first step is acknowledging it and understanding that insolvency means different. Once you become insolvent, there's some different rules that apply to you as a director, okay? So once you stop paying bills on time, once your liabilities are more than your assets, or let's say somebody takes some legal action against you, like a CCJ, your responsibilities as a director change. You're legally obligated to now act in the interests of the company creditors and not the shareholders. That is a huge shift in responsibility. You're not going to work now to make money for you and the other shareholders. When you're at work, you can't be making the creditors' positions any worse. And if you don't respect this, this is what leads to personal consequences. Listen, if you're watching it, you're unsure whether you're insolvent or not, or you're having a tough quarter, pick the phone up. You can call me on 0800 086 2766, or you can book a meeting with me in the description below, and we'll give you a bit of a help on understanding and assessing your company's financial help. Now, let's just talk about the duty shift of a director when you're insolvent. Once you become insolvent, your responsibilities have changed wholesalely. Now, under normal circumstances, you go to work and your responsibility is to the shareholders and the overall health of the business. But when insolvency is on the table, your primary obligation switches to the company creditors. Now, this is why this shift matters. The duty shift is there to protect creditors from a company that may be taking excessive risks to stay afloat. It means you must act in a way that preserves the value of the company's assets rather than taking risky moves to salvage the business at all costs. And this is what it means for you. If you're continuing to operate as if it's a business as usual, this could lead to wrongful trading allegations, which we're going to cover later on. The key takeaway is this: once you recognise insolvency, every decision must prioritise creditor interests. Now, if you're facing this shift and you aren't sure how you need to approach it, we're here to help. We offer free, independent and impartial advice. Give us a call or book a meeting in the description below. I want to talk to you about how to avoid a wrongful trading accusation, because one of the biggest risks directors face during insolvency is the allegation of wrongful trading. Now, it occurs when a director continues trading while knowing the company can't realistically pay off its debts. Now, if a liquidator finds evidence of wrongful trading, they can and will hold you personally liable for some or all of the business debts. And I'll tell you how wrongful trading works. Let's say your business is struggling. You know you're insolvent, but you keep on taking debt. You keep on getting supplier stuff from the suppliers. You take out other loans, hoping things will turn around. If it becomes clear that the company is insolvent and you continue to trade, liquidators may take the view that this is irresponsible and they can make you personally responsible for debts incurred after insolvency. There was a massive case that's happened recently where the directors of British Home Stores, they paid like £1 for the business, and then over the next year or so, well, you can read up about it, and they were made personally liable for millions and millions and millions. Now, the way to avoid wrongful trading is to document all decisions carefully. Now, if you think there's a reasonable chance of recovery, and what I mean by that is recovering your business, getting it back onto an even keel, gather evidence to support that belief. Financial forecasts, business plans, opinions from people like me, insolvency practitioners, your accountants. Show that you're acting in good faith. And with a small business, it might just be an email between directors as to why you're keeping going, or an email to yourself as to why you're keeping going. Now, again, if you're concerned about wrongful trading, we can review your decisions and we can advise you on the best course of action. Book a call, give us a call, 0800 086 2766. One thing that can really land a director in hot water is something called a preference payment. Now, you should avoid these. A preference payment is when you repay one creditor over others while the company is insolvent. Now, it's usually because of personal ties or pressure. So it could include paying back loans to family members, close friends, or even prioritising certain suppliers that you've signed a personal guarantee with over others. And the reason why this is a problem, once you become insolvent, all creditors are meant to be treated fairly. So if you repay a certain creditor and leave others without payment, a liquidator may view this as favouritism. And they have got the power to reverse these payments, and they can hold you accountable. Now, the way to how to avoid preference payments is keep detailed records. Avoid prioritising creditors based on anything other than legal obligation. And if you're not sure if a payment could be considered a preference, hold off and seek some advice. Because there are scenarios where you may need to pay a supplier to keep the business going. And in that scenario, it's arguable that doing that, even though it could be seen as a preference payment, is a benefit to the creditors because it's going to allow the company to get more money in to hopefully get some money back to creditors. Again, the key to this is taking advice. I want to talk to you about personal guarantees in insolvency, because personal guarantees are another area where a director can find themselves at risk. If you have signed a PG or personal guarantee for a business loan, a supplier agreement, those debts aren't going to disappear in insolvency. And if your company can't pay the personally guaranteed debt, the creditors can come after you and your personal assets. So it's important you've got to understand your liability. If you've signed a personal guarantee, that means a creditor can pursue you for repayment from your personal funds in the event of an insolvency. Now, this could include your savings, property, or any other assets. And it's crucial to know what's at stake. Now, lots of directors sign personal guarantees with no idea that they'll ever get called upon. They're buoyant, they might be trying to get some growth in the business and they're taking on debt to grow the business. They might see it. Directors, I think, are looking at things with rose-tinted glasses. Before you ever take a personal guarantee on, I want you to really think of, what would I do if this goes wrong? Your house is at stake. Please think carefully before taking this type of debt on. Now, if you do take on a personally guaranteed loan or some other debt and it gets called on in the event of an insolvency, in most cases, you're going to be able to negotiate with that creditor. Most of them, they just want their money back. So in 99% of cases, in an insolvency, you'll be able to negotiate the terms over a number of years, hopefully cap interest. Most people don't get made bankrupt on these scenarios. They've got to restructure those debts going forward. And if you need some help with personal guarantees, we have a wealth of experience. One of our extended team just deals with it all day, every day, and he helps directors negotiate with PGs. Again, if you're unsure how a PG is going to impact you, get in touch with us. I want to talk to you now about the importance of accurate records. Now, keeping accurate records isn't just good business practice. It is essential if you're facing insolvency. Because a liquidator is going to review your books, and if they can find discrepancies, it can be a red flag that leads to further investigation. Now, this is what a liquidator looks for. They'll be checking for any signs of mismanagement, wrongful trading, preference payments, inconsistent or missing records, because it can give the impression of negligence or, in the worst case, fraud. Now, the way to protect yourself is to make sure your records are up to date and clearly organised. Keep notes on decision-making processes, especially when it comes to payments and creditor management. Transparency here could be your best defence. Again, if you're concerned about the state of your records, we can guide you on what's required. Please seek professional advice early if anything I've said on this video worries you. Because one of the best ways to protect yourself and your business and your personal assets is to seek professional advice early. If you work with a good insolvency advisor or insolvency practitioner, they can give you the tools to navigate insolvency effectively. Now, the benefits of early action is the sooner you involve someone like me, the more options you've got. We can help you understand what your responsibilities are, manage risks, and even negotiate with creditors. But you've got to trust and find the right advisors. Look for professionals with experience in insolvency who understand the unique challenges that you face. It's a big decision. It's like a divorce. Hopefully you'll never do more than one divorce and you won't go through more than one insolvency. So you don't jump into bed with the first insolvency firm that you find. Do your due diligence. Have lots of conversations with them before you pay any money. Check their reviews. Make sure they're the right fit for you. Listen, in uncertain times, expert guidance is invaluable. And if you are facing insolvency or you just want to know what your options are, give us a call. Book a call in the meeting section below. Call us 0800 0862 766. We're here to help protect you, your business and your assets. We offer free, independent and impartial advice. Thanks for watching.